Hello, and thank you for joining me for The Wisdom of Wealth, a show where we help educate Canadians about fundamental financial literacy topics to help you make better and more informed decisions and to know when and where to reach out for help. I'm Jason Pereira, and I have the privilege of being your host. Today on The Wisdom of Wealth, we're going to talk about something that affects the lives of all Canadians, estate planning. Estate planning is just a technical term for what happens to your stuff when you die. And because it has to do with dying, many people avoid the subject as much as they possibly can because they don't want to think about it. In fact, surveys show that just about half of Canadians don't even have a will. And those who do, the majority haven't updated in the last 10 years. Let me urge you, if you are one of these people, please do something. The most heartbreaking experiences of my career involve seeing the families of deceased people resenting their dead loved ones because they didn't take the time to organize their affairs before they died. I don't know about you, but I want to be remembered fondly by the people I love and not resented. If you die without a will, it's known as dying intestate. When that happens, everything you have gets distributed according to rules set out by the government. For some, this is fine, but for others, this can be a real problem. For instance, most people assume that everything would go to their spouse. But in Ontario, it's not the case. The first $200,000 goes to a spouse, but after that, your spouse got to split the rest of the assets with your kids and can end up with only 1/3 of your assets. Also, the government would get involved and protect the kids' rights to their assets. In some cases, this situation can endanger the surviving spouse's ability to support themselves. But situations like this can be easily avoided with some basic planning. When you die, everything falls into one of three categories: joint, designated, or estate. Joint assets are things you own with someone else, typically a spouse. When you die, the ownership passes on to the other owner. If it is a spouse, they can inherit and take over your share. If those assets have grown in value, there are taxes to be paid. But if it does go to a spouse, they can put off that tax bill until they die. But for everybody else, the taxes are due. Another cost that you can avoid with joint ownership is probate. This is a fee that's charged by the courts for processing your will. Because joint assets are outside of the will, they don't attract this cost. The fees vary from province to province, but in Ontario, they're up to 1.5% of the estate. Because of this, many people choose to try to put everything they can to joint ownership, even with their kids. I caution you, be very careful here and get qualified advice when doing this. Doing so can expose your assets to your kids' creditors, divorcing spouses, and even lead to unintended results when you die. In fact, I almost never recommend this for my clients. The second category is designated assets. These are assets and accounts that let you name a beneficiary. When you die, these assets transfer to the beneficiary without probate and outside the will. There are only a handful of assets you can do this with: RSPs, RIFs, pensions, TFSAs, and insurance policies. In the case of RSPs, RIFs, and pensions, they can transfer to a spouse with no taxation. But when that spouse dies, it's taxed as income. One catch here: you have to name a person as a beneficiary, otherwise these assets get paid to the estate and are subject to probate. Everything else you own makes up what's known as your estate. These are the assets that you need to leave a will to take care of. So what's a will? Simply put, it's a series of instructions and wishes for what you want to happen to what you own when you die. It also names the people who will play up to one of 4 different roles in the management of your estate. The first person that you need to name is an executor or estate trustee. This can be one or more people or even a trust company. The executor is the person who is in charge of making sure that your wishes are followed. This is a lot of work. They have to identify the deceased assets, pay off debts, file and pay taxes, cancel memberships, return IDs to the government, and then finally distribute all the assets to the beneficiaries. It's not so much an honor as it is a job. And it's a job that comes with liability. Executors can be penalized or even sued for not handling things properly. And because of this, it also comes with compensation that's paid for by the estate. The second group of people listed are beneficiaries. These are the people who will get your wealth and your stuff. There are a few things you need to consider when naming beneficiaries. You should take into consideration personal need, fairness, and maintaining family harmony for those you leave behind. The third group of people you could end up naming in your will are the guardians. This is important if you have minor children, as these are the people who are choosing to raise them should you pass away. One important thing to note is that this is not fully official. It's simply your wish. If you pass away, your named guardians will have to apply to the courts to obtain official guardianship. Your wishes in your will weigh heavily in this decision. But should those guardians not be suitable, the court could ignore those to protect the welfare of the children. The last role to be named in your will is that of trustee or trustees. When you leave assets to people in your will, you can leave them either outright or into a trust to be managed by a trustee on behalf of that beneficiary. You may choose to do this for various reasons. If you have a beneficiary who is a minor or disabled or just irresponsible with money, having someone else manage those funds could be a better option than leaving them outright. While wills take care of your affairs when you die, what about if you're alive and can't make decisions for yourself? That's where powers of attorney come in. These are two different documents where you can name different people to make decisions for you. The first document is the power of attorney for property. With this, someone can pay your bills and manage money on your behalf. The second is a power of attorney for personal care. This allows someone else to make medical decisions on your behalf. When naming anyone to be part of your estate planning, as power of attorney, executor, trustee, guardian, or even beneficiary, it's important that you make smart decisions. Be sure you choose people who are able to handle the responsibilities they are being assigned. Someone who's bad with money may not be a great power of attorney or executor. Make sure that you have the right people and the right roles to ensure success. One other key thing to do as part of your estate planning is to get organized. You can find various estate record keepers online that provide you with a place to store all your information for your executors in one place. In addition to that, just keeping records of account statements, insurance policies, other important documents in one place will save your executors a lot of time and aggravation. So what's all this going to cost you? Well, it depends. But one thing I can promise you is it's going to cost a lot less to deal with this before you die than for the people you leave behind after you die. If you have a very simple case, there are very cost-effective online legal kits like willful.co that can cost you anywhere between $100 to $250. But if you have any degree of complexity in your life, this simply won't do. You need to speak to a lawyer. In my experience, a decent estate lawyer will cost you approximately $600 to $700 per person as a starting price for wills and powers of attorney. However, the more complex your case is, the more expensive it gets. If you own a company, foreign assets, require a trust, or have any kind of complexity in your case, the cost can get into the thousands or more. But as I said before, the cost of doing things right is far lower than the cost of not planning. And often, this planning pays for itself because lawyers can identify opportunities to reduce your tax obligations. Now, all of what I've discussed today is a touchy subject, and it oftentimes is hard to even get started in dealing with all this. In order to discuss how you can get started and get the ball rolling for you and your family, I've asked my colleague, author, and speaker, Tom Deans, to join me. Thank you for joining us today, Dr. Tom Deans, author of Willing Wisdom.
Great to be here, Jason.
Great to have you. So, Tom, tell us how the average person gets started in this path of trying to get their estate affairs in order.
Well, it's a great place to start because the reality is 12.5 million Canadians don't have a will. So what a great place to start an interview on the subject of estate planning. Most people don't know where to start.
Exactly.
They don't know how to start. It's a scary subject. It feels, and there's a lot of superstition, right?
I have encountered that. With my own family, I've encountered that.
You know that. Yeah. So if I write a will, talk about a will, go to a lawyer, have a will prepared, and certainly if I sign a will, people think I'm going to die. The reality is, we don't know when we're going to die.
Exactly.
Most people leave this subject way too late. They figure they can, I don't know, they'll have ample time. Maybe they'll get sick, they'll be in a hospital, they'll have time to prepare a will. The reality is we don't know when we expire.
I've literally been at hospital bedside fixing up new wills. It's the absolute worst time to be doing it.
Yeah, and I don't know a lawyer who hasn't done a hospital bedside will. And you've got family in the hallway. You've got the lawyer popping in, trying to figure out, the list of assets. You got someone, everyone's in a heightened emotional state. It is the absolute worst place to be doing what we're talking about today.
Absolutely. Good. So first steps. Someone wants to get their affairs in order because they saw this show and they decided, you know what, I really need to be not one of these 12 million Canadians who's not organized. First steps, what should they do? Who can they go to for help?
My answer to that question may surprise you. A lot of people will think, well, go see a lawyer. I would say go see an advisor who has hundreds of clients, who has sent them to better lawyers on this subject.
Absolutely.
There's a lot of lawyers who do this on a part-time basis, and this is an incredibly complex area of the law.
Absolutely.
So don't go to a lawyer who's doing a divorce at 9 a.m., real estate at 11, and maybe gets to wills in the afternoon. This is a complex, difficult, and constantly changing area of the law. Go to your advisor. The advisors will have a good list of lawyers who do this full-time. They write wills full-time.
Absolutely. And it's important. Always deal with a specialist. I mean, the number of terribly drafted wills that I've seen in my career is shocking, and they're not worth the paper they're written on. In fact, sometimes they create more problems than they solve. So besides the lawyer, let's talk about how the advisor can facilitate the estate planning for the client.
Well, it's a great question. I think the best place to start is we've been left with this idea that a will is something that we manufacture in the comfort of our own home by ourselves. It's a solo journey, a solo conversation. And I think that's why a lot of people don't get wills written, because it's so overwhelming, and people are embarrassed. It's a full Latin language. Right?
Yeah.
People don't want to feel like they don't know the basics, so they leave it alone. Here's what I've written about. I believe that when families can sit down with their advisors and have a family meeting and talk about the orderly transition of assets, whether it's cottages or cars or art, it doesn't have to be even a lot of money. But when families tackle this in an open, transparent way, they have the most successful estate plans. But how do most Canadians do it? It's surprise.
Yeah,
right?
Your parents dead. Here's what they wanted. What do you mean that's what they wanted?
And everyone is reeling in shock going, well, why would they leave that to this person and this to this person, and when it should have been the other way around? And then we often get the families we fear, not the estate plans that we design. We are so overwhelmed by the emotions that we don't have these conversations. We draft wills in private, and we create all sorts of challenges for surviving family. Really, this is where people should start with estate planning. How do I design an estate plan that leaves my family thriving and succeeding when I'm not here? You know how most people start estate plans?
Go to the lawyer.
They go to the lawyer, they go to the wrong lawyer, they go to a lawyer, or they go to an accountant, and they say, I need to do an estate plan. How do I save tax?
Yeah.
Dude, you're not here.
Yeah.
Tax is the easy part. But
tax is the secondary part. I say
Absolutely.
the most important part is leaving your family intact, because I'm sure you've heard it, I'm sure you've seen it, and I've seen it countless times. One of the biggest reasons I see families break apart is arguing over what happened in the estate, right? And that can be any number of things. It can be arguing over family heirlooms, and the big one is the family cottage, right?
Huge.
Oh, we're going to share this cottage.
Huge.
I don't know about you, but I didn't really get along sharing stuff with my brother when I was a kid. I can't imagine us getting along sharing things when we're older, right? It is a big issue.
Yeah, and I would say jewelry is a big second place. Things that are worn close to the body, things with a large emotional content, watches, brooches, those types of things. It's not about the value, it's about someone else having them.
Exactly.
And I'll tell you, when we die intestate, you covered that in your introduction, when we die without a will, that provincial formula, which chops up a business, a family, assets, according to that formula, those, how do you chop up a watch?
You don't, right? You can't, right?
You can't.
There's a dollar value to it, and if that watch is worth $50,000, someone's getting the watch, but someone else is getting $50,000.
Someone wins, someone loses.
Someone wins, someone loses. Someone doesn't get the watch they want.
You got it.
And then on top of that, is that person even think it's worth $50,000? Those cause arguments, right?
It's crazy.
So wherever we can facilitate the conversation beforehand, and this is, again, a very touchy subject, right? People don't like talking about debt. They don't like talking about money with their kids. But, if what you care about is your family being thriving and strong and close to each other after you're gone, this is incredibly important.
I think it is important, and really what I'm writing about is I think we've been led to believe that wills are really about other people just getting our stuff. In your introduction, you talked about when we go into the lawyer for our will, we come out with two other documents. One's called a power of attorney, which is a document that has a huge import for people who are alive. It says if you bump your head, you're unconscious, Here's who I've assigned to write checks and keep my financial affairs going while I recover.
Absolutely.
And we do,
yeah.
right? If you don't have I don't know anyone who's got a power of attorney who doesn't have a will. In other words, we go in for the will, we come out with the power of attorney, financial power of attorney, and power of attorney for health care. That's another document, a estate planning document that's very much about the living.
Huge.
It says, if, God forbid, I'm lying in a hospital and my family hears the words irreversible brain damage or vegetative state, they know what to do. Mm-hmm. They know what to do. What a beautiful gift to give your children, not to have to sit in a grieving room in a hospital and try to figure out when the appropriate time is to plug or unplug.
Yeah.
You name a kid that's going to get that right. Someone is going to feel for the rest of their life that they moved too quickly or didn't move fast enough. So when we have these documents and share these documents with our family, not when we're dead, but when we're alive thinking clearly, and I'll come back to dementia, these are the great gifts that we give our family. For a very, very tiny cost, we give our families great gifts, the gifts of planning.
Yep. You know, like I said, it was the cheaper option to do it now, regardless of the cost, compared to later on. And let's not even get into the family dynamics issue. I mean, not having this, as you said, I mean, can you imagine if I've seen cases where one child is in medicine, the other one's not. One child fully understands what's going on, the other one does not. And there's a conflict over what to do about mom or dad because, hey, like, I know they're never coming out of it. No, but there's a hope. And it's like, well, they're not going to. And they get into an argument that causes a rift between them, right? If you had simply said, like, these are my wishes, and this person understands that capacity, that they know that my wishes are going to match whatever the scenario is because they have a background in it, it's their decision to say yes, right? But I give them that permission, right? And one little thing people don't realize is that, and this is a little tip for all the parents out there, is that when you're a parent, your kid's a minor, you have control over those sorts of things. The second your child turns 18, you lose that control. So I often tell and have my clients when their kids turn 18, go get powers of attorney. They may not need a will because they don't have assets at this point, but they do need powers of attorney for their kids.
I think they're great gifts.
Absolutely.
I think they're great gifts to give our children. When our children turn 18, you're absolutely right. They're young adults. The law doesn't say, well, they're young adults. I say to adult parents all the time, you want to give yourself a gift? Buy your kids wills, power of attorneys, and healthcare directives when they're 18. Now, it's their job to keep them up to date, right? Not yours, but they're adults, and it's a great way to make a statement that, listen,
now you're in charge of your own affairs.
Grow up.
Yeah,
grow
exactly.
up.
Yeah. So basically, let's just imagine a family does the right thing. They sit down, they discuss what's important to everybody, who's getting what, and they come to a general agreement that hopefully they're going to follow later on. I mean, I think that's powerful because it's one thing to hear it from your parents while they're alive. It's easier to understand those with their wishes versus seeing them on a piece of paper that's cold and maybe thinking, well, maybe they didn't understand what they were doing, whatever it might be. So basically, now that they've had this conversation, what's the next steps in facilitating the entire experience?
Well, I'm a big proponent of family meetings, and the best quality and feature of a family meeting is everyone hears the same thing at the same time. It's not, a parent dying and you have 4 kids and one says, just before Dad died, he pulled me aside and said he wanted me to have the boat. It's like, dude, we had a family meeting.
Yeah.
All 4 of us heard the same thing.
We heard the boat's getting sold.
We heard the boat is being sold,
exactly.
And we're going to divide the cash. So what a great gift to leave our children, a plan that is transparent, that has been discussed, noodled, written down, and understood.
Absolutely.
This idea of putting surprises at the center of estate planning, I don't understand it.
No, I don't get it.
I don't understand it.
It's like you get shell-shocked by what actually happens in it. So you mentioned and touched upon an important factor, while you can do it. So this brings up the issue of capacity. So let's discuss what that is and why it's important in estate planning.
Capacity, it's a big issue. So one in 3 Canadians over the age of 65 are presenting some symptoms of dementia. We are living vastly longer than any previous generation on the planet.
Absolutely.
And I'm going to say the D word, we're dying differently. We have heart attacks, we get stents, we go for another 20 years. The mortality rate of men, it's the fastest, most improving demographic, but we are languishing. Hospitals and medicine is fantastic for fixing us up and sending us home. There's a big chunk of retirement where we're not swinging a golf club or a tennis racket. We're not swinging anything.
That's it.
We are at home and we're lying down, and we're lying down for a long time, and it's expensive. My last surviving grandmother died at 98. We spent $2.5 million providing really high quality in-home care, $250,000 a year for our grandmother.
Yep.
Canadians are completely underestimating how long they're going to live, how expensive it will be, and because we are living longer, dementia is affecting relationships, it's affecting our finances, and family is having to step up and provide, if not direct care, then the oversight of that care. So let's go back to where we started. We got a family that shrouds their finances in secrecy. The next generation, kids don't know how much money their parents have or where they want to live or how they want to live in retirement. Guess who's paying the price for that? It's not the kids.
No.
It's the people who are controlled by the fear around opening this conversation up inside the family. Give yourself a gift. Sit your kids down and have this conversation. It can be in a restaurant. It can be at a cottage. It doesn't have to be in a boardroom with everyone wearing ties. Make it informal, but make this conversation frequent and consistent and update your plans.
Yep, and I've seen it happen. I've had cases where I've been on clients to update their wills because previous ones didn't match and there was a superstition around it, whatever it was. And then unfortunately, someone suffers a stroke. There's a capacity issue up to that moment for whatever reason. Not every stroke leads to capacity, but that one did. And now that will is written in stone.
Yep.
Whatever was there, even if it was wrong, even if it wasn't what they wished anymore, if you leave money to people they don't even know anymore, it's written in stone because you can't change it anymore, right? So it's something that we ought to do when we are, quote unquote, sound mind and body, because otherwise any kind of change is going to be invalid.
You know, this subject, Jason, has eluded some of the most successful politicians, business owners, wealthy people.
We've had stories recently, right? Celebrities.
There's almost a month doesn't go by when a celebrity isn't in the news for messing up their estate.
Yep.
Absolutely messing up their finances, messing up their family. Aretha Franklin, Prince, the list goes on. 1968, Bobby Kennedy. Right? He was assassinated in Los Angeles.
And he was a lawyer. He should know better.
He was a lawyer. And guess what? He had a will. Good news. He had a will.
Okay.
But his brother was the executor. He was assassinated 5 years earlier. The will was never updated. He wasn't just a lawyer. He was the Attorney General.
He was the Attorney General of the United States, and he didn't bother updating his will.
So, look.
Oh, boy.
Yeah. So, really, even if you're wealthy, even if you're super smart,
Yep.
no, this is complex, but it doesn't have to be.
Yep.
Those situations were ruled by fear. Overcome the fear, open the conversation up with your family, work with your advisor, and have them lead you to a really good qualified lawyer.
Absolutely.
And I'll tell you, $205 million. Today, $205 million will be inherited in Canada. Today, tomorrow, and every single day in this country for the next 10 years. $755 billion. There is so much money that is being inherited. So much money, and most of it is being inherited chaotically, causing all sorts of distress and conflict because people don't know where to start.
And it's interesting. Oftentimes we have the conversation surrounding, oh, what's this going to cost? I don't like paying lawyers, whatever it is. You know, the general is about paying lawyers. And I said, well, if you don't want to pay the lawyers, you have a choice. You can pay them a little bit now, or you can pay them a heck of a lot more when you die.
You can pay them a tiny, tiny, tiny bit now to write your will, or you can do nothing and watch your children lawyer up and grind $1 million, $5 million, $50 million estate to zero.
I've seen that happen. I've seen even with people in my own life where 3 years of struggle in court just to be named the executor. Never mind the entire disbursement of the assets or who gets what. It was just a fight over the executorship because neither side trusted each other.
It's outrageous.
It is.
It's absolutely outrageous.
It is. The amount of money blown was incredible.
I say to people all the time, if you think divorce is expensive, that's like a dress rehearsal for the really big show.
Yeah, for dying without a will. That's
dying
for
without
sure.
a will is just insane.
Yeah, especially the more complex your case. I mean, we talk about blended families, right, where your second marriage is in there. If you're talking about having a corporation in place, you know, we saw the examples of the super complex ones you mentioned, like Prince. Can you imagine, like, how do you manage Prince's estate without a will? Like, how many different licensing agreements, you know, how many different assets does this man have, houses, like, that was just utter negligence.
Yeah,
but
the lawyers will mop the floor with the family's money.
That's it. So if you don't like cutting checks to lawyers, you're going to be spinning in your grave if you don't get a will done in time.
I get more phone calls from elderly women who read my book, and again, men statistically pre-decease, right? I get more phone calls from elderly women, and you know what they tell me?
My husband didn't bother putting a will together.
Yeah, and you know what they say? They want to bring their husband back from the dead and kill them themselves. They are so angry.
Yep.
They're grieving, but they are so angry that someone didn't take an hour to meet with a lawyer and get the basics in place. There is absolutely no excuse.
Yep.
And There's a reason why 12.5 million Canadians don't have a will. It's a little bit like fraud. When a family member dies without a will, they are so embarrassed by that fact that they don't tell that story frequently. They're so embarrassed that culturally we continue to die without wills. And like fraudsters, you know why fraudsters continue to practice their craft?
Because people don't speak up.
They're the people who have been duped by a fraudster are so embarrassed by doing something so simple like not responding to an email, right, or answering the phone, or doing something stupid. They don't tell their stories, and so it continues to go on and on and on. So part of what I'm trying to do with this book and these public lectures and
now let's talk about this book. So the book, what is the message and the story behind the book?
Yeah, the message is really to help families start this conversation. That's it. I mean, that's all the book tries to do. It gives 7 questions. It offers 7 questions that kids can ask their parents. Parents can ask their kids just to start the conversation and say, look, it's not about me trying to grab more stuff than my brothers and sisters. In fact, all of us want to sit down together and find out, what do you want? How can we serve you when you get older? But how can we put the frickin' lawyers out of business? I mean, not out of business.
I actually know a lawyer who specifically started a conference off by saying, hey, we're actually planning ourselves out of business because by making sure that clients have their affairs in order, we are reducing our total lifetime income. But you know what? It's the right thing to do. If you want to be the wrong guy on this part of the equation, go right ahead. But guys like me are going to make sure that guys like you have a hard time making a living. Yeah.
No, I mean, in fairness to the lawyers, we have 12.5 million.
But they're charging because they have to. Like it's their work.
There's 12.5 million people without a will. At the very moment in time where we're actually inheriting more money through the laws of intestacy, people who don't have wills, I think what's happened is the lawyers can't make money writing wills. If you sit them down, they are struggling. It's not like the old days. So because there's lots of competition, you can go to Staples and get a will kit for $19. It'll be largely a disaster.
Well, the one I showed you online, you can update as many times as you need to for life, and you can start a single family $250.
Yeah, there's no. The bottom line is there's no excuse
for simple wills.
No excuse.
Exactly.
Yeah. Get started. So I wrote the book to give people the confidence, to give them the basics. Right? It's not an overly technical book at all. In fact, it's a book about 4 people sitting in a lounge in Las Vegas having coffee and drinks and having a meal.
It's very human. It's not technical.
We need some humor around this subject. Maybe I'm trying to put the fun back in funeral, but I'm just trying to get people to say, look, enough of death using us and abusing our families and destroying our wealth. Let's flip it. Let's use death to bring urgency to this conversation so that families can sit around, have a meal, and celebrate their good fortune, their discipline to save for retirement. Let's have that conversation so that money transitions efficiently and unchaotically and releases potential in the next generation to start businesses, fund education, take care of health care. I mean, that's called legacy. And we are so afraid of talking to our family about legacy. I don't understand it. But I'll tell you, when we can overcome that fear of dying and we can have these conversations and get our documents in place and bring transparency to our affairs, man, watch families thrive.
Great. And I think it's a compounding of stigmas, right? There's a stigma about talking about money in the first place and a stigma about death. You put those two together and there's a lot of momentum to overcome. But I'll tell you, when you've been through the experience of having a negative experience where someone didn't leave a will, the last thing you ever want to do to your family is put them through that, because you've seen the horror show that it can be. Anyway, Dr. Tom Deans, I thank you for joining us. And where can people find you and find your book?
Best place is the title of the book, Willing Wisdom, willingwisdom.com.
Okay, perfect. And thank you yet again for joining us for The Wisdom of Wealth, where we hope to improve your financial literacy and help you make better decisions just a little bit every week. I'm Jason Pereira. Until next time, take care.